Hey you guys, welcome back to my channel. This is your girl Najwa. I am so happy you're here. Let's talk about this crazy RICO case. Okay, so we saw the first televised hearing, which when you get to the point where your democracy is so in jeopardy because of crazy people who should have just retired a long time ago, but like they're caught up on some autocratic trip just to retain power. They're knocking down gay people, knocking down black people, knocking down Asians, everything just to keep toppling onto that power. The fact that you gotta bring up RICO charges like this legitimate mafia enterprise, like the fact that we even have to televise this stuff today points to where we are right now. But let's look at this together, guys. I want to go ahead and caveat and say I am not a lawyer. This is the remote to my air conditioner. It's hot. I'm not a lawyer, okay? I am not a lawyer. I don't know anything really about the law or anything like that. But I just feel like because of social media, we have just lost our sense of using common sense these days. You know, it's like people can't delineate between the good guys and the bad guys anymore because it's like we have become so brainwashed by technology, fake news, misinformation, extremists, that it's like we don't even understand anymore just how to like use common sense. I'm someone who used to watch crime shows like Law and Order, NCIS, Criminal Minds. My dad and I used to watch Criminal Minds all the time. Luther, Hawaii Five-0. We understand who's the bad guys and who are the good guys. Why are we having problems with this right now? I feel like Donald Trump and his whole team did the wrong thing messing with Fulton County. Like, as someone who grew up in Atlanta, Georgia, they did the wrong thing. Now, let's look at this together. The judge basically said he's not going to sever this crap. Let's look at it together.
Take up more time than any one of us would have.
Okay, have at it.
Thank you, Your Honor. Your Honor, I want to start off by saying we recognize this is a RICO prosecution. We recognize that, and we do recognize that part of RICO is, providing prosecutors, at least the state would argue this, and there is some case law to suggest this, providing prosecutors with a little more ability to bring in conduct that's maybe broader than had they charged a direct crime, for example.
So this is where these MAGA Republicans are going to try to be like, I understand that the Justice Department just needs to carry out what they're doing, but, with RICO and blah, 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 this is where the real con men meet actual law, and it's like, nah, bro, that don't fly in here. We're not operating on everybody just sucks up to the orange elephant and you'll be okay. No, this is like actually the judicial system. Doesn't work like that.
In this case, there are, I would argue, 3, 4, or 5 separate alleged conspiracies really contained in one alleged conspiracy in this indictment. Mr. Chesebro is only concerned in terms of the evidence or allegations with what I'm going to call the alternate elector alleged conspiracy. The allegations contained in the indictment, and of course I'm not saying that I believe they are true, but accepting them as true, shows that Mr. Chesebro, at most, was only involved in that aspect of the conspiracy. Specifically, the allegations showed that Mr. Chesebro received approximately 18 emails, all in his role as an attorney for the Trump campaign, asked to opine on the application of the 12th Amendment to the United States Constitution and the Electoral Compact, and then several other emails. Most of those additional emails were simply transmitting the memos that Mr. Chesebro wrote that are alleged in the indictment, and 1 or 2 other emails to certain state officials discussing the logistics of how to go through the Electoral Compact. So that's what I'll call the alternate elector alleged conspiracy. Mr. Chesebro has been indicted as part of that conspiracy. He's alleged to be part of that conspiracy. Obviously, we will defend those charges, but that's conspiracy A, if you will. Then there are 2 or 3 other conspiracies. With all due respect to Ms. Powell, And nothing I say, of course, in this should indicate whatsoever that I'm commenting on the evidence against Ms. Powell. And I apologize. I know that's not Ms. Powell, but her representative, Mr. Rafferty. Ms. Powell is alleged to have engaged in a conspiracy, again, just accepting the allegations and the indictment is true, dealing with the computer systems down in Coffee County, Georgia. And those computer systems, as we allege in our indictment, Mr. Chesebro, or I'm sorry, in our motions, Mr. Chesebro is not even alleged to have undertaken anything, even remotely related to.
All right, we can go ahead and stop it right there, y'all. We can go ahead and stop it right there. Okay, so basically, the reason that I'm going to stop it right there, and we don't even have to look at much more of what this individual says, and in a second, I will tell you his name. His name is Scott Rodman, if I'm not mistaken, representative for Kenneth Chesebro. We don't have to take it any further because basically what he's doing is that little sort of GOP aggro nerd just hyperventilating. It is absolutely atrocious that you just would even do this, and it's just like that, like persona of white privilege, white supremacy, just like absolutely horrified that you would have the audacity to call them out on their BS. Dude, get with the program, okay? Yes, they were not involved in Coffee County, allegedly, directly, allegedly. Sidney Powell and Kenneth Chesebro never actually communicated in person or not in person, allegedly. Okay, cool. But let's try to bring this out a little bit, okay? Let's take a little macro look out of here real quick. The reason that this is all happening is because Donald Trump, unwilling to accept that he lost the 2020 election, tried to overturn results. Not to even mention bringing all of this into context with some modicum of emotional intelligence that the man has made the best country on earth. Yes, I live in Europe, but I am American of birth. The best country on earth, okay? And turned it into basically a third world country where black people, where brown people, where gay people are being slaughtered in the middle of the street, okay? The fact that this person sent people to harass Ruby Freeman and Shay Moss, okay? These people that he won't mention. The fact that all of his staffers worked and colluded together, you know, they collaborated together. That's why you're facing RICO charges, is because you've been behaving like a mafia instead of behaving like the leaders who should run the leader of the free world with fair democracy, with ethics, with scruples. I'm sorry, y'all. Like, I know I'm on a whole nother level right now, but this is like, for millennials, I think we're finally at our boiling point, because this is what we're gonna have to inherit. Right now, boomers, okay, Gen Y, they are in control of most of the seats of leadership within government, but eventually millennials and Gen Z, we're gonna have to take this crap up. Look at what you're leaving us, okay? Kenneth Chesebro and Sidney Powell. First of all, like, we don't even have to discuss how ridiculous it is that they're trying to sever their case from the rest of the case. Put it all together, guys. Anyway, guys, either way, it friggin' sucks. It friggin' sucks, and these people don't understand that this is a part of a much larger issue, okay? Kenneth Chesebro and Sidney Powell, if you guys are really innocent, just let the Justice Department play out. Just let the justice process play out. You know, if you are really innocent, you're just gonna let things play out. You know, think about maybe when you've had, I don't know, a disciplinary review at your job. I don't know, for example, and maybe somebody on your team there was some bad behavior involved, but you were not involved in that bad behavior. Maybe you'll go into it a little bit nervous, but for the most part, you're good because you know that you weren't involved in that stuff. Like, this right here reflects to me that sort of persona of, how dare you? How dare you have the audacity to come to me? The other thing is, as a black woman married to a white man, And people don't want to talk about race these days. But Donald Trump and his cronies really made it that way. If we were really living in an anti-racist America right now, we wouldn't have to talk about race so much. But it looks like we're going to have to talk about it a little bit. I just have to say this as a black woman married to a European white man. So this is the original, guys. White people really have a problem with like cognitive dissonance and black and white thinking. I'm sorry, it's groupthink, and it goes back to like communism and like the monarchies and stuff. It even goes back to Neanderthals, guys. I'm telling you, I really truly believe this, of where it's like, I can only focus on this one thing at this one time. This category goes in this box. This category goes in this box. Black people from tribal backgrounds, it's just like, we can think a little bit more fluid than that, because things are about our bodies and like intuition and how stuff feels and stuff. I don't want to blanket for everybody, but like, it's just like this, right? If you even look at it, go and look on YouTube. I tell you what, go and look on YouTube. There's a video talking about the anatomy, the different anatomy of Democrat and Republicans' brains, legitimately. And I'm a centrist, but like there's some differences in our brains. Even the way that we eat, like Republicans are much more like meat and potatoes type people, whereas Democrats, they like to try stuff from other cultures and stuff. I mean, I'm telling you, I'm really telling you. So it's just like, these people are representing that. How dare you have the audacity to come to me and talk about this stuff? All the meanwhile, they have been committing atrocities. It's also like, how can this guy be talking about conspiracies? Donald Trump with QAnon, the red pill, the Marxist left, all of this crap, those are the real conspiracies. Like, you guys have been doing bad. It's just that simple.
Powell, I'll go ahead and start the court off with Henderson versus State, and I've highlighted it for the state. And may I approach, Your Honor?
Sure.
And if you go towards the second to last page on the back, I've highlighted that for the court and for opposing counsel. So as you'll see at head notes 40, 41, and 42, like it says, everything's basically in your discretion. But in this case that just came down a couple weeks ago, what we were talking about is sort of highlighted in regards to sort of similarly the facts in our case, right? The first issue is going to be, is there going to be any confusion about the evidence? Are there conflicting defenses, antagonistic defenses? And in the end, is there going to be confusion as far as that goes? There will not be any antagonistic defenses because the two people don't overlap at all in the indictment or any evidence that I've seen.
Again, it don't matter what you think about you not thinking there's an overlap. This is out of your hands. They don't respect power. They don't respect authority outside of Donald Trump. They don't respect the judicial system.
The issue is going to be, what's the confusion? And one of the remedies is obviously jury charges. And in your case, the question becomes, how many jury charges can you bring, can you provide to the the jury, as far as trying to understand all these types of things? So this case that I gave you is a RICO case involving gang-related type charges. And what it basically says is, those two people were charged with the same crimes. And in the end, the court didn't sever those matters. We don't have that here, right out of the gate. There's no antagonistic defenses, so I'm not going to get into factor 3. There's really just overflow and spillover as far as that goes. And so the question is the evidence against Ms. Powell going to impact her? And the reason I say that is, we're charged in the RICO and then 6 predicate acts. The predicate acts only deal with the elector slate, as far as who filled out the electors, was that fraudulent.
All right, y'all, let's stop it right there. Let's stop it right there. It's just like, I've already watched this, and I don't even need to watch it again because I can summarize it for you very succinctly. It's hyperventilating Republican white men just being like, oh my God, how dare you bring this to my client, Kenneth Chesebro and Sidney Powell. They had nothing to do with that. You're going to have so much on your plate already. You're going to have to look at fraud with the election machines. You're going to have to look at wire fraud. You're going to have to look at this. You're going to have to look at that. Don't look at my client, Sidney Powell. Don't look at Kenneth Chesebro. Are you guys getting what I'm saying? Like, I feel like we live like in such the age where that's like, I don't know, people aren't able to think for themselves anymore. They need social media to tell them what to think. Even some of y'all right now are like, oh, Nadra, dang, thank you for telling me what to think. Like, seriously, just use your common sense. Why aren't these lawyers using their common sense? I know they're in it for a buck or whatever, but even more importantly, why aren't the clients using their common sense? Why isn't Powell and Chesebro using their common sense? Guys, you effed up. The minute that you didn't get out of this mafia masqueraded as a presidential administration, you effed up. The minute you started doing bad things on behalf of this crazy person, this senile elderly person who refuses to let power go, who excuses white supremacy, who excuses sexual abuse towards women and actually enacts those things. The guy who just is xenophobic, is racist, is sexist, misogynistic, just a horrible, disgusting human being. The moment that you started saying, this is the face of America and I'm going to protect it, you got all wrapped up in this. Let the judicial process play out. I mean, I feel like I don't have to show you much of those clips because honestly, it probably will make you want to barf up your meal. It probably will make you want to barf up your lunch or your breakfast or whatever it is that you just ate, because watching it one time through was like that for me. Now, what I want to highlight here is, what do you think, and as someone who grew up in Atlanta, Georgia, you know, and I feel like there is a very clear reason that Atlanta was targeted. There's a clear reason that Atlanta is a swing state. It's because Georgia done been through it, baby. When Sherman marched through Georgia and burned Atlanta down, Georgia already knew. There has been harmony between black and white in Georgia for some time. I'm not going to say that harmony is perfect, but for the most part, I feel like Georgia, in a way, I'm not trying to like get on some other level because Georgia has its problems. Look at my videos about the Real Housewives of Atlanta. Atlanta, Georgia, Fulton County, whatever, it has its problems. But there is a harmony between the races there, you know, and I just know that from my upbringing. I know that from being from a family that is not, I didn't grow up rich, y'all. I grew up very, very middle class, working class type people, you know. My mom was a teacher, an elementary school teacher. My dad owned a painting business and was an aspiring writer on the side. Like, my background is not, you know, I didn't have silver plates, but even with that, growing up in Atlanta, Georgia, I was around Jewish people, I was around Indian people, I was around white people, around Asian people. Like, Atlanta, I'm going to say really is like, y'all don't mess with Atlanta. They say don't mess with Texas. Don't mess with Fulton County. I literally was talking to my brother on the phone the other day, my oldest brother, and I was like, what do you think about all this stuff? And he was like, Donald Trump ain't gonna get away with none of that crap in Fulton County. Like, no, you done messed with the wrong one. And I think they're slowly starting to realize that. But beyond that, the inherent arrogance of the GOP right now, that they basically can make up the rules as they go. They're finally facing justice. Justice might be slow to catch up sometimes, but it always catches up. And they're finally getting to the point to realize, okay, I guess we don't make the rules. No, you don't make the rules, baby. So that's what they're doing. They're coming in here and they're trying to say Sidney Powell has nothing to do with this. Kenneth Chesebro has nothing to do with this. Throw this out. They're trying to tell the judge what he should do. You don't need to focus on this stuff. You're going to have so many other things to focus on. The election machines, like, that stuff might have worked in the Donald Trump administration. It doesn't work in a place where people actually have a brain. Y'all tell me what y'all think, because I don't know. Watching these people makes me think I'm losing my mind. I love the way that Fulton County Atlanta prosecutors really highlight how they're so much more functional and healthy. Just look at the difference of mannerisms even between, and I know that they're technically not a team, Scott Rodman and Brian. Now listen to this one. This is Brian Rafferty.
here, the court has the discretion under the Speedy Trial Act in federal court to still push the case down because some other defendants, as we have in this case, have said they're not ready for trial. That's ordinarily what happens in federal court. But here in state court, looking at the state law and the state Speedy Trial Act, by virtue of our demand and the various severance motions that other defendants have filed saying they're not ready for trial, I think Ms. Powell has to be severed out from the remaining 17. And so the question for today, in my mind, is whether the trial of Ms. Powell will be joint with Mr. Chesebro or not. I think based on all of the law that I've seen, and I haven't seen anything to the contrary, her demand for speedy trial cannot be trumped by the desire of the government to try everyone together when other defendants have moved to sever and said they're not ready. And so that's sort of the first point I wanted to just make, is although the court hasn't issued a scheduling order, I think we are on the same path as Mr. Chesebro about when this trial should happen. Which leads us to sort of the second question about whether or not Mr. Chesebro and Ms. Powell should be tried together. And I echo many of the things that my co-defendants counsel have said, although I have a very different view of the evidence and the evidence as it relates to Ms. Powell. I'll just point out in the indictment, the government was kind enough to list on page 16 or 17 or 18 a summary of the various manner and means of the indictment. And if you look at that, you'll see that Ms. Powell had nothing to do with most of it. Ms. Powell had nothing to do with false statements to state legislators, nothing to do with false statements to high-ranking government officials, nothing to do with false electoral college documents,
to that independently
nothing to do
without
with
you
the election worker here in Fulton County, nothing to do with solicitations of the Department of Justice, nothing to do with solicitations to the Vice President. The only thing which she's alleged to have involvement is, as my co-counsel have said, is this Coffee County matter. And frankly, Your Honor, the way the government has characterized that, the evidence is going to show they're incorrect. She was not the driving force. The evidence will show that she was not the driving force behind that there were other lawyers not mentioned in this case that were actually the driving force behind that. We've submitted a Brady request already to the government before this hearing, asking for a host of different kinds of exculpatory material that we believe the government has that will show that. That will show that she was not the person that was behind this, has been alleged in this indictment. Her typewritten name does appear on a contract, but she never signed the contract, and the contract isn't even for Coffee County. It's for another state, and she never signed it. And the most important part of this case, Your Honor, with respect to the Coffee County aspect of this case, is the question of authorization and whether or not the visit down there was authorized or not. And there's a lot of public documents that are out there that demonstrate that numerous folks associated with Coffee County authorized that visit. The video itself shows that.
Crazy.
Ms. Powell's name appears maybe a dozen times in this indictment. She has nothing to do with the electoral college aspects of this, which is going to involve all sorts of complex testimony about constitutional issues and things of that nature. Her only involvement, as alleged by the government, is what happened in Coffee County, and even that they have wrong. So why does that matter? Because my presentation, my cross-examination, my case is going to depend on my ability to present to a jury that she had nothing to do with what the government says she was involved in Coffee County. The evidence is not going to show what they say. But all of that, all of my efforts, is going to get washed away in days or weeks of testimony, perhaps, about the Constitution and whether or not and under what circumstances and alternative electors can be put in place, and whether the legal opinions of Mr. Chesebro and others have any sort of legal validity. All of that is going to be prejudicial to my client. She's going to be sitting there for days, if not weeks, listening to this kind of testimony when the case as to her in Coffee County really boils down to one day, January 7th. That's it. The whole case is about whether or not that visit was authorized and what, if any, role she had in it, which is very little, if none. So, you know, she's going to be prejudiced by all this other testimony about things that she had nothing to do with. And as a matter of judicial economy, you have discretion, as my counsel have said. You have the discretion to make a decision about the interests of judicial economy. I don't think a trial about Coffee County, if that's what we have a trial about, is going to take weeks or months. I think the trial could be over in a couple of days. Most of it is on video that a lot of folks have seen, and there's a handful of emails, and that's really it. There isn't that much evidence. And so when the court thinks about its discretion about how it can exercise that discretion and move this case along, move Mr. Chesebro's case along, the best way to do that, frankly, is to try the cases separately. And I would ask the court to just exercise the discretion that it has, that my co-counsel have already set forth, and sever Ms. Powell's case from Mr. Chesebro so she can get a fair trial. I'm prepared to answer any other questions, Your Honor. I think I've laid out my arguments.
Let me take up one, again, as it relates to the traditional framework. I think Mr. Chesebro's team took this up, but one of those, obviously, is the antagonistic defenses. Are you joining their position that you don't anticipate that being a consideration here?
I don't think that there's antagonistic defenses because, as my co-counsel has said, my client doesn't know Mr. Chesebro, has never met him, has never really spoke with him. There's no emails or documents or anything else. What he's accused of has absolutely nothing to do with Ms. Powell at all. And so I don't see that as antagonistic. It's just that evidence presented at a trial with Ms. Powell is going to prejudice her in the same way that Mr. Chesebro's lawyer said that evidence about whatever Ms. Powell did would prejudice Mr. Chesebro.
Okay.
Thank you, Your Honor.
Thank you.
All right, y'all, let's talk about this. Now, first of all, I don't understand what the antagonistic defense is. Again, I'm not a lawyer, but I do have half of a brain, and I did make it up to a MBA, okay? So I do have 3 different post-secondary sort of educational experiences under my belt. I think, I mean, I've watched a lot of criminal shows. I feel like it doesn't take a rocket scientist to see that. Just, okay, hold on. Let me pull back for a second. That, I think the person that we just saw is, so that's, I got my notes here, and I was just on it, and now I lost it. So that was Sidney Powell's lawyer, right? That was Sidney Powell's lawyer, and his name is, I think, Brian Rafferty. I'm pretty sure that's Brian Rafferty. And, you know, just, I don't have to feel it real. I feel like I don't really need to be a lawyer to just comment on tone, okay? To comment on tone, to comment on mannerisms, to comment on, I mean, for lack of better words, even politeness, you know, even just sort of like an emotional intelligence in dealing with one's counsel, in dealing with one's casemates. You know, I look at the prosecutor's office and they sort of deliberate and talk with one another. You can see them collaborating. There is an air of collaboration around them. When you look at Rodman, you look at Rafferty, it's just, there is a lot of what seems like arrogance and sort of, I'm still looking for that note, y'all. I literally had it in my hand and I changed the page and now, okay, yeah, here we go. It literally is arrogance and sort of that, like I said, that how dare you have the audacity to call me out even though I know that I've been doing wrong. You know, Sidney Powell and Kenneth Chesebro and Rudy Giuliani and Navarro and Trump and every single person involved in this, it's like Heather Dubrow said, you know, like if everybody is telling you that you're dead, maybe it's time for you to lie down. At the time, I really didn't like when she said that, but now I'm starting to see, maybe there was some wisdom in that. Guys, let the judicial process play out. Fulton County prosecutors come in with some logic and some sensible doggone thinking. They lay this out in a way that is common sense. Listen to this.
Briefly lay out a few things that the court has asked the state to be prepared to respond to. Firstly, we will contend that a trial of these 19 co-defendants will take 4 months. This is Nathan Wade. And that does not include jury selection. And it's also
Special
predicated
prosecutor
upon
for the
whether
state,
or not,
Nathan
of course,
Wade.
The defendants elect to testify or not. But 4 months is our time estimate. In terms of the number of witnesses, they're in excess of 150 witnesses that the state intends to call. 150 witnesses.
150 witnesses.
Judge, we contend that we must prove the entire conspiracy against each and every one charged. Each and every one charged. So the court, in the interest of judicial economy, would have to make the decision as to whether or not the court wants to try the same case 19 times or 2.
Not 19 times.
Well, to be clear, when you say 2, Has your position evolved from your filings of last week or from lately?
It hadn't. It hadn't, Judge. I just throw out the number for just to give the court the difference in the number of times and the number of man hours it'll take to try the case, once or twice.
Well, when you say twice, who's involved in each case?
Obviously, the two who've requested severance here.
All right, because up to this point, I thought the state's position was all 19 need to go on October 23rd.
It is, and that continues to be our position.
Okay. And just to clarify that and flesh that out a bit, you're saying that right now you would predict that if it was just a trial of Ms. Powell and Mr. Chesebro, that the state's going to need those same amount of witnesses, those same amount of exhibits, and that same amount of time?
Absolutely.
Okay.
So, okay, this right here is, again, even though I'm not a lawyer, very clear for me to understand. This right here, like the fact that Trump and his allies have even brought us into this point where people are on the streets starving to death. They can't feed their kids. They have to go, some people have to go into debt to go to the hospital to go get treated for their illnesses. Black people, brown people, women all over the place are getting rejected from jobs, education, universities, etc., that they are qualified for because Trump has created an environment of a boys' club. He's turned America into a boys' club. The fact that we even have to sit here and spend government resources that could be allocated to helping everyday people who don't have millions to just throw out at any moment's notice. And some of these people don't have that either. But still, back to the point, the fact that we have to go here and do this, I think Nathan Wade, the special prosecutor, is making that very clear. Like, we don't got, I feel like there was a little misunderstanding between him and the judge, but he nipped it in the bud real quick, basically saying, we don't have time to be trying every 19 of these individuals individually. It's all a delay tactic. Okay, this is all coming from the top to the bottom. What does Trump do? He delays. He delays, he denies, he lies. It's the same thing, you know, and don't believe that if Sidney Powell and Kenneth Chesebro want to sever theirs, that every other single one of them wouldn't, if they were successful in doing this, don't think that every single one of them would want to run in and do that too. Now, I love John Floyd's testimony, not testimony, his argument, I guess, I don't know. This was nice. Take a listen to this.
We move through, of course, the statutory and case law parameters under which Your Honor has to make this decision. 1784A, of course, states that when two or more defendants are jointly indicted, such defendants may be tried jointly or separately in the discretion of the trial court. And our case law, we're relying on Collins versus the state, 312 Georgia 727. Three factors to consider are the likelihood of confusion of the evidence in law, the possibility that evidence against one defendant may be considered against the other defendants, and the presence or absence of antagonistic defenses. And I guess the position of the other side is that neither is saying that three is an issue, that there doesn't seem to be any antagonistic defense. Of course, neither the mere presence of an antagonistic defense nor the possibility that a separate trial will give a defendant better chance of acquittal is sufficient to sever. The defendant bears a burden of showing that a joint trial would be so prejudicial as to amount to a denial of his or her right to due process. So I want to talk about what's not a proper ground for severance first. And this is coming from Mr. Chesebro's motion to sever. He says, in sum, there has never been any direct contact or communication between Mr. Chesebro and Ms. Powell. Similarly, there is no connection or overlap between the overt acts or the substantive charges associated with Mr. Chesebro and Mr. Powell. That is not a defense, and that is not a ground for severance. Similarly, Ms. Powell's motion says that Ms. Powell can receive a fair trial only if she's tried alone. The prejudice that would inure to her from a lengthy trial with any of those she was not involved with, and about the vast number of events she had no knowledge of or connection with, would deny her due process. Again, not a defense, not a ground for severance. Turning to case law, Lowry versus the state, 347 Georgia App 26, a 2018 case. Nothing in Georgia's RICO provisions requires that Lowry, the defendant in that case, have participated in or even been aware of all the alleged acts of racketeering activity committed in connection with the common enterprise. Thompson versus the state, also Georgia Court of Appeals. None of the provisions of the Georgia RICO Act requires that each defendant in an enterprise have full knowledge of all facets and elements of the enterprise and all of its members or actors. And likewise, the federal courts agree. This is an 11th Circuit case, 1996, United States versus Castro. In proving the existence of a single RICO conspiracy, the government does not need to prove that each conspirator agreed with every other conspirator, knew of his fellow conspirators, was aware of all the details of the conspiracy, or contemplated participating in the same related crime. And so we've heard a lot from both defendants about they didn't know the other people. They were located thousands of miles apart. They didn't even know that the other parts of the conspiracy were going on. But the case law is clear that that does not matter. Of course, anytime a person enters into a conspiracy, they are liable for all of the acts of all of their co-conspirators. And that's it. Evidence against one is evidence against all. And as Mr. Wade noted to the court, the state's position is that whether we have one trial or 19 trials, the evidence is exactly the same. The number of witnesses is the same. And so many of the arguments that are made on the other side evaporate. I want to look at the cases that were cited by Mr. Chesebro in his motion. Griffin versus the state, that's a case where severance was properly denied. It is not a RICO case. Brown versus the state, another case where severance was properly denied, not a RICO case. Baker versus the state, severance was properly denied, not a RICO case. Padgett, severance properly denied, not a RICO case. Jones versus the state, severance was properly denied, also not a RICO case. Zafiro versus United States, federal case. Again, severance was properly denied. That was not a RICO case. Henderson, which we just received just now, that was also not a RICO case. Severance was properly denied. Mr. Chesebro points to a couple of cases in his motion where a conviction was reversed on appeal. And as the court pointed out, in those cases, what the appellate courts found was that at trial, the evidence against one defendant was minimal, almost nothing compared to the evidence against the co-defendants. And so it was just fundamentally unfair that there was all this evidence that applied to one, very little that applied to the other, and the jury may have been confused. Look at Defendant Powell's list, and most of these are the same, so I'll click through them. Again, same cases, most of them severance properly denied, none of them a RICO case, and the ones where a conviction was overturned on appeal, again, it came down to insufficient evidence at trial. The evidence against the defendant named was just so minimal compared to the evidence that was pertinent to the other defendants charged. And of course, conspiracy cases, and more specifically, RICO conspiracy cases, are different. And that's why we point out that all of those cases relied on by the other side are not RICO cases. And so the analysis is different. The facts are different, and the law is different. Looking to our Georgia courts, Pasha versus the state, 273, Georgia App 788, 2005 case. Each actor in a conspiracy is responsible for the overt actions undertaken by all of the other co-conspirators in furtherance of the conspiracy. Willingham versus the state, Georgia Supreme Court case 1995, where there's sufficient evidence of a common scheme or plan to commit a criminal offense, joinder is authorized. And our federal courts kind of take both of these concepts, and in United States versus Caporali, 806 F. 2nd, 1487, an 11th Circuit case here in Atlanta in 1986, joinder of co-defendants in a count charging a single RICO conspiracy violation is permissible, even if different defendants are charged with different acts of racketeering, if the racketeering acts charged are in furtherance of the overarching RICO conspiracy charge. And in our case, the state's theory of the case, and as laid out in the indictment, each and every one of those 161 overt acts charged, and all of the offenses charged from count 1 to count 41 were all in furtherance of the same overarching RICO conspiracy, which was to unlawfully affect the outcome of the 2020 election in the state of Georgia. Every single one. I understand the other side's argument that, my clients over here in Coffee County, my clients over here in Wisconsin or wherever sending off emails. But the problem for them is that it doesn't matter because it's all part of the same overarching RICO conspiracy. And the state's theory of the case, as alleged in the indictment, is that as this enterprise operated in multiple states and operated quite a lot in Fulton County, that's why we have this case here in Fulton County, the conspiracy evolved. One thing didn't work, so we move on to the next thing. That thing didn't work, so we move on to the next thing. That thing didn't work, so we move on to the next thing. And that was going on from the first overt act to the last overt act, all part of that same overarching RICO conspiracy. Turning back to the factors that the court needs to look at, and I'm just going to kind of talk about factors 1 and 2, the likelihood of confusion of the evidence in law, and the possibility that evidence against one defendant may be considered against the other defendant. Of course, 3, which the other side agrees is not an issue here. But 1 and 2, because this is a RICO conspiracy case, and because the evidence against one is admissible against all, 1 and 2 evaporate. There's no likelihood of confusion about which evidence applies to which defendant or which law applies to which defendant when all of them are alleged to have engaged in the same conspiracy. And it's significant that in count 1 of the indictment, the RICO count, the allegations set forth in counts 2 through 41 are all included in that count 1. And so while, Mr. Chesebro may have never been to Coffee County, the evidence about Coffee County is evidence that the enterprise existed and shows that the enterprise was working. And because it's a conspiracy case, Mr. Chesebro is liable for what happened there, and it's admissible evidence. Again, going back to our federal court, since any evidentiary spillover, and the court asked about this issue, since any evidentiary spillover is vitiated where the evidence in all events would have been admissible against the movement, in the context of a conspiracy, severance will rarely, if ever, be required. This is a First Circuit Court of Appeals case, and we submit that as persuasive authority here. Turning to another example, United States versus Diaz, a Second Circuit case from 1999, and a federal RICO conspiracy case from the Second Circuit involving the Latin Kings. Even when a defendant was implicated in only one of 9 separate murders carried out as part of a pattern of racketeering activity, a joint trial was proper because all of the evidence was admissible against each and every one of the defendants to show multiple things, not just that they committed an act, but to show the existence and nature of the RICO enterprise and to show a pattern of racketeering activity on the part of each of the RICO defendants, as well as his or her relationship with the enterprise itself. And I just love this quote because I think it sums it up. Again, it's an 8th Circuit Court of Appeals decision, persuasive authority, but there in United States versus Kehoe, the 8th Circuit said that it will be the rare case, if ever, where a trial court should sever the trial of alleged co-conspirators. The other side pointed a little bit to this, but I did want to mention that any potential jury confusion can be addressed by other means other than severance, such as an instruction to the jury to separately consider the evidence as to each defendant. Now, again, the state's position is that because this is a conspiracy case, because it's a RICO conspiracy case, that all of the evidence is admissible against all of the defendants. But even if that, even if there were some issue or to be extra cautious, the court could give a limiting instruction. And the state's position is that it would not be limiting instruction after limiting instruction after limiting instruction, because again, all the evidence is admissible against all the defendants. Also, the defendants completely ignore a long line of cases in Georgia that affirm the denial of severance for Georgia RICO Act violations, all decided under these same principles that I've just talked about. First, Chancey versus the state, Georgia Supreme Court, 256 Georgia 415, a 1986 decision. Evans versus the state.
I think we've got the sites here. We can get those later.
Sure. And those are provided to counsel, and Your Honor, I have copies of those as well for you. So under these principles, the defendants cannot satisfy the first 2 prongs: likelihood of confusion of the evidence in the law, the possibility that evidence against one may be considered against the other, because that's allowable. That's exactly what a RICO conspiracy case is allowed to do. I don't think I need to talk too much about the 3rd prong because of the statements of the other side. Just would hit that defendant has to show that a joint trial as it relates to the 3rd prong would have to amount to some sort of a denial of a due process right, and we don't believe that's the case here. Palmer versus the state, just to point out a few, Georgia Supreme Court case where the Palmer court highlighted certain situations where there was an antagonistic defense, Barge, Metz, Lauren, and again, won't get into those because of where we're at. But the bottom line there is that it has to be prejudicial as to amount to a denial of his or her right to due process. I also want to talk about public policy. Public policy, and our courts have hit on this issue, strongly disfavors severance in complex conspiracy cases for several reasons. One is judicial economy. There's been arguments on the other side that somehow severing any of these defendants out would be more economical. I'm not quite sure how that works. I think one 4-month trial is shorter than multiple 4-month trials. Same witnesses, same evidence. Minimizing the inconvenience and trauma on victims and witnesses. And I want to remind the court that part of this RICO conspiracy involves victims. There are victims in this case that were targeted by members of the enterprise, and their lives were turned upside down. And that's an important part of this case, and having those people come and testify multiple times over and over would both inconvenience, but more importantly, traumatize them. Consistency of the verdicts. And I've got a little bit of case law that talks about that. Efficient use of state resources and fundamental fairness. Justice Scalia astutely observed, it would impair both the efficiency and the fairness of the criminal justice system to require, in all these cases of joint crimes where incriminating statements exist, that prosecutors bring separate proceedings presenting the same evidence again and again, requiring victims and witnesses to repeat the inconvenience and sometimes trauma of testifying, and randomly favoring the last tried defendants who have had the advantage of knowing the prosecution's case beforehand. He goes on to say, joint trials generally serve the interests of justice by avoiding inconsistent verdicts, enabling more accurate assessment of relative culpability.
There are victims.
And he points out that these are sometimes advantages that operate to a defendant's benefit. So even apart, he says, from these tactical considerations, joint trials generally serve the interests of justice by avoiding the scandal and inequity of inconsistent verdicts.
Y'all, I want a Fonnie Willis Barbie doll.
Economic use of resources.
I want a Fonnie Willis Barbie doll, please.
An important and legitimate concern.
Thank you.
Montgomery versus the state, 156, Georgia Act 448, a 1980 case. In a case where the same witnesses, the same evidence, and the same charges would be used against all defendants, thus affecting judicial economy in the use of physical facilities, time of witnesses, jurors, and court personnel. The trial court must consider these efficiencies against the possible conflicting interests of joint or multiple defendants. And the 11th Circuit, again, agrees. United States versus Brown, 2007 decision 505 F3rd 1229. We find considerations of judicial economy to weigh heavily against severance in light of the substantial systemic interest in handling this complex conspiracy case in one trial, and in that case, it was a 2-month trial. State, as we've represented to you, Judge, believes that this would be at least a 4-month trial. So defendants, the state's position, have not met their burdens as to any of the factors set forth in Collins. The case presents no likelihood of confusion of the evidence or law applicable to any defendant because all of the evidence is applicable to all of the defendants. All of the law is applicable to all of the defendants. And 2, evidence against any defendant may properly be considered against each of the defendants in a RICO conspiracy case, so there's no risk of this spillover effect. Just to mention 3, again, they concede that that's not an issue here. That's all I have, Judge, unless you have any questions.
Just a few. So these, again, the 3 factors, those are just, would you agree that those aren't exclusive?
Yes, Your Honor, absolutely.
All right, so we're really supposed to take into consideration the circumstances of the entire case and anything that just might be present in this case. It may not be in others, right?
Yes, Your Honor.
So I guess some of the things I think we need to think through, to me also, it's more this position that we still need to have all 19 people at the table 47 days from now. And maybe this is something, if you need to tag team in with somebody else on the council, one of the first things I kind of want to talk through is potentially how removal affects this. So I know your state is currently litigating this issue with multiple of the co-defendants in federal court. And while that's happening, until a decision is made, we can't issue a judgment of conviction here, right?
Yes, Judge.
Now, no matter how Judge Jones rules, isn't either party going to have the right to appeal that ruling?
That is correct, Judge. Our position is that both sides would have the right to appeal.
And so the 11th Circuit could take any idea of how long to weigh in?
As long as they need to.
Right. So it could potentially even optimistically be a 6-month turnaround just for the 11th Circuit to come up with a decision, right?
Yes, sir.
So if it's a 4-month trial that starts in October, we're potentially sitting at a point where we've presented the entire state's case. Maybe even the jury has returned a verdict, but we can't enter that judgment of conviction until the 11th Circuit comes to a decision. Is that kind of the scenario we're playing out here?
Judge, I think...
Excuse me, if we can have a moment, Judge.
Now this is where emotional intelligence comes in, because they're actually taking a moment to align with one another, to talk with one another.
And by the way, let me add, I know this wasn't something that I highlighted, so if this is something we need to submit for, post-hearing briefing, we can do that, but this is something that I think is a consideration we ought to be taking into mind.
Sure, and that may be the best route, Judge. Our kind of position on that is it depends on what the scope of Judge Jones's order is. If he takes the position that he removes everyone, or that he just removes those who may have, some entitlement to removal, the law is a little unclear on how that works in a criminal case.
But you can see what would happen. No matter how he rules, if let's say he says that some aspects of the case stay behind with us here in Fulton County, and the 11th Circuit changes their mind and reverses that entirely and says, no, the entire case has to get removed to federal court. Where does that leave us in the middle of a jury trial? Is double jeopardy attached? Have you now risked your entire prosecution because this case has now been removed to federal court and we've sworn in a jury and it's been presenting evidence against all these other co-defendants?
Judge, again, I think for those very complex kind of fine-tuned details, we may need the opportunity to brief those issues.
It's not easy, and we've got, again, less than 2 months to figure this out. So I think to kind of charge ahead without coming to some thoughts on this very soon might be risky. And then the other issue here is even if we say that the 3 prongs aren't met, again, just dealing with the logistical issues, the state's case may take 4 months, but voir dire with 19 defense attorneys is going to be a different animal than voir dire with 2. So I don't think saying they're both going to equally be 4 months, no matter how many defendants are involved, would be completely accurate. Is that fair? In terms of who can object? Just at any particular question that's asked, the sidebars that are requested, just the sheer physical limitations if one attorney gets sick. Is it really so, can we so confidently say that each trial is going to be exactly 4 months, no matter who's involved?
I don't think we can say exactly, but I think it kind of cuts both ways, Judge, because if we had, for example, 19 people tried at one time, you have a witness up, and let's say they're subject to 19 cross-examinations. Of course, each of those 19 is not going to be the same full-length cross-examination. So you would have kind of a shorter, if you took them all together, you might have a shorter time for that witness on the stand with 19 people versus if you have 19 trials of one person. And I'm going to the extremes just to demonstrate the point. But if you have 19 trials with one defendant each, then each of those would be each of those witnesses would be fully cross-examined 19 times. So there's a give and a take. Some things might take longer, some things would be quicker.
So the other things to think in mind is this is going to be a case with a lot of pretrial motions. And again, I don't know how many hearings we're going to need to have to sort through all those. But if we compress our timeline to 40-something days, our ability to even be able to really weigh those and think through these issues, again, it just seems a bit unrealistic to think that we can handle all 19 in 40-something days. That's my initial reaction. thinking of just how to get this, and are we even delaying the inevitable? If we say there's no severance, aren't we going to have 17 defense attorneys get up here and file motions for a continuance just saying they're not ready? I think we've already had some counsel indicating they're on trial in other cases in federal court. And if we're just going to be sitting in a position where we're having to consider a continuance motion in 40 days, why delay the inevitable?
Sure, Judge. State's position on that is that we're here on 2 defendants. And so at this juncture, other defendants have filed their motions for severance, and they may raise those issues. And it would be appropriate for the court to consider all of these issues in making its decision. But for today's purposes, we're here on 2 defendants. And the issue is, do we pull these 2 defendants out? Not do we pull, defendant 13 out or whatever the case may be. So the state's position is until those are raised by those parties, once we have hearings on those, that they shouldn't affect the court's decision as it relates to these 2 defendants.
Okay, so at a minimum, I think what I'm hearing here is that it might be appropriate at this time to consider whether Mr. Chesebro and Ms. Powell proceed alone together.
Whether they have provided the court and met their burden to show that they should come out. Not that the other 17 should come out, but they should come out of the pot is the state's position.
Okay. All right. Sure.
Have like 2 minutes to respond.
Sure. Last word from the defense since it's your motion.
So, Judge, I will take this down.
Your Honor, I'm not trying to oversimplify this because it is a complicated case, both factually and procedurally. However, as to the 19, Your Honor, there can't be a trial of 19 people, and it has nothing to do with the...
Okay, guys, let's talk about this. My husband got me a new iPhone. I said, this will make me better with the phone. Maybe. Anyway, so guys, let's talk about this. First of all, I want to just say there is a level of respect. There is a level of respect with the prosecutors, with the special prosecutors that's really not there with Trump's people. And I really think that this is a culture thing. I think that the GOP of today has entered into this time where it has exited away from compassion. It's exited away from doing the Christian-like thing, the Jesus-like thing. It's exited from a place of really just humility. I look at Special Prosecutor John Floyd, who did a wonderful presentation, by the way. I look at him and I sense humility. Now, his defense took some time, right? It took some time. It took some time for him to lay out the quotes. The fact that it's historically severing one co-conspirator from the other co-conspirators is just not a wise thing to do. Obviously, that would make sense to us. But the fact that he has to sit here and spoon feed it to us is kind of sad. But the thing is we've come into such an age right now with all of the just sound bites. It just seems like the far right, the GOP right now, exists on sound bites and on clickbaity headlines. And people of today have taken that. They've taken that, and they can no longer sit and listen to a 10-minute thing that's going to really explain something in the way that it should be explained, or storytell in a way that it should be storytold, or convey something through, for example, there are people who can't sit down through an hour and 30-minute film these days, so because they've watched so many, 6-second bumper videos on Instagram and YouTube and TikTok that their brain is like friggin' melted out, and some of those are our parents and grandparents as well. It's not just young people. And so I think we've gotten into this age where we want to see things in like this little soundbite modicum, but it don't work that way. It don't work that way. Sometimes you need to be thorough. Sometimes you need to explain things. Looking at Mr. Rodman and Mr. Rafferty get up, and while I can say that they seem to be knowledgeable in what they do, like I said, I'm not a lawyer, I'm not an expert, but they seem to be knowledgeable in what they do. But in comparison to Mr. Floyd and Mr. Wade, there is less of a sense that I get of humility. Now, this is me. Like I said, an opinion is like a booty hole. Everybody got one. My mama said that. My dear said that. My grandma said that. So I say it, An opinion is like a booty hole and everybody got one. But, my opinion is that the delivery from Mr. Floyd, from Mr. Wade, it was logical. It made sense. It was common sense, although they are very experienced in the law. For me as an everyday person, it makes sense to me. It makes sense to me from even a compassion place, even just a human emotional intelligence place. They are talking about the victims here. And this right here really highlights why the law is in place, because it exists for the victims. The victims in this sense has been the Georgia electors. It's been us. It's also been everybody in the United States, because the fact that Trump just thought he could play us, he and his allies just thought that they could play us just to hang on to power. Go to Russia. If you want to live like that, go live in Russia, okay? That's not America. That doesn't reflect what American democracy is. Now, let me just say something about this judge. His name is McAfee. And for those of you guys who grew up in Atlanta like me, you'll know there's lots of roads in Atlanta called McAfee. So I wouldn't be surprised if he comes from a long line of Atlantans. I wouldn't be surprised if he probably comes from a long line of people who worked in the law. But you can clearly see that this guy knows what he's talking about. I feel like I probably shouldn't say this. I don't know. The coverage I've been watching, everybody's been saying, ooh, he thinks that this is not realistic. I feel like Democrats right now are playing a CYA game. But I feel like he knows which way is up. I feel like, okay, I guess the best way I could describe it is, guys, I work in advertising. So I've worked in a lot of agencies. He seems like the creative director, and I'm an art director, but he seems like the creative director. And sometimes when you work in an agency, there will be people who come in from the brand, so like me as an art director, I work with all types of brands. But sometimes people from the brand, whatever that brand might be, like I'm just giving Dove as an example. I'm looking at my deodorant. Say Dove is the brand that I'm working for. And, I'm working on some work for them, like a campaign for them, but their employees come and sit in our office one day. And we have to work with them to work on this campaign. We're all working on the same thing, but it's a little bit different, the structure of an agency versus working inside the brand. The creative director is the one who smacks all of that together. He's the liaison between the brand and the advertising agency. I know that's kind of rudimentary, but I guess that's the best way that my brain is kind of piecing this together. This judge is seeing both sides of the coin, and at the end he's going to deliberate and decide in which favor this should go. I feel like I don't want to speak too soon, but I feel like this is going to end up with on the victim side. There were real victims in this, and it actually doesn't just end with Georgia. I feel like the real victims is every single American. That's why this case is so important. And the delay tactic of, I like the way that, what is his name? John Floyd. I like the way that he puts it of like, there's also judicial resources at hand here. Like, are we going to sit here and pay to friggin' have 19 of these trials, of these hearings, and there's 150 witnesses? Are we going to make every witness go through this trauma every time? And there's trauma attached to this. When you listen to Scott Rodman, the representative for Chesebro, or Brian Rafferty, the representative for Powell, when you listen to them, did you hear at any point where they talked about the victims? Never. You never ever heard that. At least I didn't hear it. Maybe I missed it. Go back and look at it if you guys remember. But, I never ever heard anything about the victims. So A, there is no regret there. B, again, I kind of just feel like this whole thing was from Trump's side, a little tactic to see if they could delay, to see if other people, if they could try and go for the same thing, if they could sever their case too. I just feel like this was a waste of time. And it seemed like the judge was like, this is a waste of time also. Like, we got bigger fish to fry. We need to get moving. So yeah, the PowerPoint wasn't the most jazzy one I've ever seen in my life, obviously, but it got the point across. You ain't severing this from this case. Sit back, let the justice system work out. Okay, so let's look at the ruling, and I'll give you guys my final thoughts.
And Mr. Chesebro, I certainly agree that there are always guardrails, and that RICO, as indicted, can't just be used to do anything, but it is broadly construed, and those guardrails are found in those three factors. And the three factors traditionally that we've gone through really don't seem to be at play here. We don't, for one, the antagonistic defense issue is conceded. Both parties are going to be claiming they have no idea who the other is and won't be pointing the fingers at each other. I think the argument that they're charged in two separate kind of silos of charges strengthens the idea that there won't be confusion amongst the jurors and there won't be spillover evidence. So really the strongest thing that I'm hearing, and I don't think it's invalid, is that it's going to be kind of a matter of inconvenience and potential added expense to have both defendants sit together. And that's certainly true, but there's also other judicial economy aspects to consider and issues of inconvenience as well. We talk about the jurors. I don't think we can take for granted that these would both be two equally 4-month-long trials. I think it could easily be twice that with multiple defendants, and I think we need to take into account the fact that one docket goes entirely on hold while this case is going. And instead of it being, if we're purely considering aspects of judicial economy, which to me was really the only valid argument here, I think taking up 2 dockets and for a period of 4 months also weighs into that, as well as the voir dire process and the inconvenience to the jurors. So based on what's been presented today, I'm not finding that severance from Mr. Chesebro or Powell is necessary to achieve a fair determination of the guilt or innocence for either defendant in this case. And so I'll deny Mr. Chesebro's motions to sever from Ms. Powell. I'll deny in part Ms. Powell's motion to sever from Mr. Chesebro. And the plan will be to enter a scheduling order for Ms. Powell mirroring that of Mr. Chesebro with the October 23rd date holding. It sounds like the state is still sticking to the position that all these defendants should remain, and they want to address some of these removal issues. I'm willing to hear that. I remain very skeptical, but we can. I'm willing to hear what you have to say on it. And so, but again, because we're on a limited time frame, I don't think we have the luxury of waiting. So, how long do you think the state needs to respond to that issue?
2 weeks, Judge?
I don't think we can do that. There's going to be motions deadlines for the other defendants, and we need to get scheduling orders entered.
I had to ask.
That's fine. And I had to deny.
Understood. 10 days?
Well, I think the 10-day mark from today. I know, again, I'm sending the indicator that folks are going to have more than 10 days to file their standard post-arraignment motions. Let's see if we can have that by Tuesday of next week. Again, this is limited to how you think logistically we could possibly keep these defendants together, and I think we can limit that to 10 pages. And if anyone else wants to respond, they can to that issue. But Mr. Grubman?
Yes, Your Honor. This is, if you're still going on this issue, I did have a quick other issue just since we have your attention to bring up. We do have a pending motion to talk to the grand jurors.
Right. Let me get to that. Okay, so, again, knowing that Mr. Chesebro and Ms. Powell are hurtling forward and the motions are going to keep coming in, I don't think it makes sense to just have these all pile up. So we would pretty much maybe just keep having these weekly sessions together and handle them one at a time. So to that end, I believe we're starting another trial next week. I think it's a murder trial we're doing next week, but looking at Thursday or Friday of next week, how's everyone's availability? I only saw motions from Mr. Chesebro, so I guess the question's only directed towards Mr. Grubman and Mr. Aurora. I'm looking at Thursday or Friday morning.
We're here whenever the court instructs us to be.
Got it.
Your Honor, could we ask for Friday morning? I'm going to do a sentencing
on Thursday morning? Thursday afternoon.
You know, Florida State hour is going to be 3, so I just figured we could have, depending on the motion, just.
Well, so far you've got, I believe it's the 2 related to the grand jury, And then you have one more related to the supremacy clause. Maybe we limit it, since the grand jury issue is something that might take more time to flesh out if it's granted. Maybe we limit it to those two for next week, and we can save the constitutional arguments for another day. Can we still do that Thursday morning, though? Assuming if it's just those two related to the grand jury. That's the plan. Yeah.
I'm sorry, John.
Sure.
Thursday morning or Friday morning?
Thursday morning, it sounds like.
Hey, y'all. Okay, to wrap up here, Prosecutor Wade and Prosecutor Floyd have humility, and they know what they're talking about. Judge McAfee knows what he's talking about. Representative Scott Rodman and Brian Rafferty, and Sidney Powell and Kenneth Chesebro. Yeah, y'all Trump and all the allies. Y'all that's pretty much it. But I don't know what y'all think. Let me know in the comments. If you are new to this channel, please hit the subscribe button, hit the bell so you know whenever I post a video. I'll see you guys next time. Bye.